Can the government prevent newspapers from publishing information if they claim national security is at stake? To find out, you have to read New York Times versus United States. But it's 22 pages. Don't have time for that? I've got you covered. This is Too Long Didn't Read, where normally I cover New York Court of Appeals cases, but this is part of a special series on landmark cases from the United States Supreme Court. This episode is on one of the most important Supreme Court cases in American history, New York Times versus United States, which can be found at 400 3 U.S. 713, published on June 30th, 1971. This landmark case, often referred to as the Pentagon Papers case, revolved around the government's attempt to prevent the publication of classified documents about the Viet Nam War that journalists were trying to put in the newspaper. To best appreciate this case, there is some helpful background info to understand. The First Amendment to the United States Constitution guarantees several protections for the people. The amendment prohibits the government from, quote, abridging the freedom of speech or of the press, close quote. It also prohibits the government from prohibiting the right of the people to petition the government for a redress of grievances. This means the people have a right to object to how their government has been acting. Next, you should know that right after the United States entered World War I, the U.S. government passed the Espionage Act of 1917. That law criminalized many things, but relevant to this case, it criminalized obtaining or delivering information relating to national defense to a person not entitled to have it. It was meant to prevent spying by punishing disclosure of national security secrets to foreign enemies. Finally, you should know that the United States was involved in military and political actions in Vietnam from 1945 to 1968, during which over 58,200 American armed service members died and over 250,000 Vietnamese died. Okay, so what are the facts here? As a result of these decades of United States military action, Secretary of Defense Robert McNamara ordered a study to be completed of the history of the Vietnam conflict. He ordered that a Vietnam Study Task Force be created to write an encyclopedic history of the Vietnam War. 36 analysts worked hard to do this. They produced a tremendous 47-volume work. The document included over 3,000 pages of historical analysis and 4,000 pages of original government documents, some of which were marked top secret sensitive. One of the people who had access to the study and had previously worked on the study was Daniel Ellsberg. In 1969, he opposed the war and, along with a friend, made photocopies of the study, intending to disclose it. Ellsberg showed the documents to several people and eventually gave 43 of the volumes to a New York Times reporter named Neil Sheehan. The New York Times began publishing excerpts of the study on June 13, 1971, and its impact was instantly enormous. These documents started to be called the Pentagon Papers. Street protests, violence, political finger-pointing, and lawsuits instantly erupted, as the articles showed that the official narrative by the United States government was not accurate. President Richard Nixon's administration then tried to force the New York Times to stop publishing more secrets from the study, arguing that it violated the Espionage Act of 1917. The New York Times refused, so the U.S. government went to court to get a federal injunction forcing the New York Times to stop publishing these documents. A federal appeals court issued an injunction, and the New York Times appealed. Meanwhile, the Washington Post then began publishing its own series of articles based upon the Pentagon Papers. What was the holding by the United States Supreme Court on whether a court could issue an injunction on a newspaper to publish articles? On June 30th, 1971, only a few weeks after the first articles were published, the United States Supreme Court issued its decision. In a 6-3 decision, the majority held that the First Amendment's protections of the press, free speech and redress of grievances trumped the claimed violation of free speech here. It was a short decision, but its importance has echoed ever since in the investigative newsrooms of this country. The majority held that a prior restraint, meaning a decision to prevent publication in advance, comes to the court with a heavy presumption against constitutional validity. To overcome this presumption against validity, the government must meet a heavy burden of showing justification for the restraint. To meet this burden, the government would have to show that publication would result in grave and irreparable danger. Applying those rules, the Supreme Court said here, the Nixon administration failed to meet that heavy burden, and therefore the presumption against allowing the injunction remained. The government could not prevent the publication of the articles. Crucially, the decision did not address anything about whether Ellsberg had committed a crime in handing over these materials, and in fact, Ellsberg was quickly arrested and went to trial on charges of violating the Espionage Act of 1917. His charges were dismissed based upon bizarre and unusual prosecutorial misconduct. Simply put, the Pentagon Papers situation and case has altered the course of United States history. It changed the course of the war and how journalists cover war documents and how whistleblowers release their information. It reinforced the power of the First Amendment and strengthened the position of newspapers and journalists seeking to publish classified or protected documents. The Pentagon Papers case stands as a testament to the enduring power of the First Amendment and its protection of freedom of the press. It serves as a reminder that a government's desire for secrecy cannot override the public's right to be informed, even when the information is uncomfortable or critical of those in power. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.